if it pleases the court, my name is Bosca, initial T, and I appear on behalf of the defendant, Mr. Featherstone, today for sentencing. If it pleases the court, I will now begin submissions for sentence. Your Honour, Mr. Featherstone is here today for resentencing for one charge of stealing. Mr. Featherstone stole a car audio system from his then employer, and upon being charged, Mr. Featherstone returned the audio equipment, and it was then on-sold and only able to be sold at a second-hand rate instead of the retail rate. My client is remorseful for his actions, and he acknowledges the harm that he has done in terms of the breach of trust that he's caused between him and his previous employer, the stress that he's caused, and the loss in profit and revenue he caused from his actions. Your Honour, my client was short-sighted, and he instructs that he had taken the equipment to do a demonstration on his podcast. He also instructs that he intended to return the equipment after he had done the demonstration. Your Honour, he acknowledges that this line of thinking is foolish, and he is deeply remorseful for what he has done. At first instance, this court imposed a community service order, and my client failed to complete the hours in line with the schedule for that community service order. My client is regretful that he only completed a small amount of hours, and he is back here today in front of you. Under section 121, subsection 2 of the Penalties and Sentences Act, Your Honour is required to take into account the extent to which my client complied with that first community service order. And while it is a small amount of those hours, he completed 24 out of the 84 hours. We submit that my client still turned up to community service and completed those hours and has made some payment in form of his time towards the punishment for his actions. Your Honour, the prosecution today want to go from the imposition of a community service order to a term of imprisonment where Mr. Featherstone serves an actual term of actual time in prison. Your Honour, and they also submit that specific deterrence ought to be at the front of the purpose of your sentence here today. We submit respectfully that it should not, Your Honour. We submit that rehabilitation ought to be the purpose of your sentencing today. While a term of imprisonment might take into account the seriousness of breaching trust in an employer-employee relationship and some minor similar offending my client has on his criminal record, it fails to take into account his age and his prospects of rehabilitating and becoming a productive member of his community. Your Honour, we are seeking the imposition of a fine today and an order for restitution. My client, Your Honour, he's 20 years of age. He's currently steadily employed in the same industry, in the car audio industry. He has a reference from his current employer saying that he will keep, my client has been transparent with him about this process, and his employer has said, his new employer said he will keep his position for him, keep him employed should he stay in the community after sentencing today. Your Honour, my client is also dealing with some mental health conditions. He has recently been diagnosed with chronic depression, and he has also been diagnosed with a chronic alcohol drinking problem, borderline drinking problem, sorry, Your Honour. He is trying to improve this situation. However, he is seeing a GP. He's receiving medication for his mental health. And this isn't without personal difficulty for my client in figuring out the dosages and the schedule for medication. And he's also attending counselling for his mental health. Your Honour, the comparative sentences, the cases that I've been able to find show that a fine is within range, as well as a suspended term of imprisonment is within range. Actual time of imprisonment we submit is outside of the range for my client's kind of offending. The first case that I bring to Your Honour's attention is the case of Godfrey and the Queensland Police Service. It's a 2019 decision for the District Court. It's a District Court decision and it's judgment number 66. In that case, Godfrey, she was a public servant. She was advanced in age. She had been employed with the department for 20 years, was aware of their policies and procedures, and she stole electronics. She stole an iPad laptop. In that instance, her offending was protracted, it was covered up, and she was only found after a colleague come over to her house. In that instance, she had no criminal history, and the court imposed a fine of $500 and no conviction recorded. The second case that we bring to Your Honour's attention is the case of Myers and the Commissioner of Police Queensland. It's a 2018 decision of the District Court, judgment number 30. That involved a 45-year-old chemist who stole upwards of $20,000 worth of pills from his employer. It was his offending was motivated by his addiction. He was dealing with mental health. He had no criminal history. However, he was advanced in age, he was educated, knew what he was doing, and had specific training as a chemist to know the interplay between addiction and receiving help from it, from medication. In that instance, Your Honour, the court imposed a 12-month imprisonment. It's wholly suspended and had an operational period for 12 months. Your Honour, my client's case and circumstance is distinguishable from those two cases. He's significantly younger and less advanced in age and less advanced in experience and has made a foolish decision here. It is less sophisticated offending. It wasn't over a protracted period of time, and the equipment was readily returned and able to be unsold in good condition, in good enough condition to be sold secondhand. Your Honour, my client is also remorseful. He entered a guilty plea, an early guilty plea, and his while he does have a criminal history, it's quite limited. And there is some small minor offending, similar offending. However, that was in the context of his teenage younger years. We submit and ask that Your Honour impose a fine under Section 45 and order restitution under Section 35 of the Penalties and Sentences Act. And the amount of restitution should be for the difference between that second-hand value and the retail value his former employee sold the equipment for. Your Honour, my client is employed. He is able to pay the fine and the restitution. This kind of sentence would enable him to be rehabilitated, keep his structure from his employment, keep receiving treatment for his mental health and his drinking condition. And if you were to impose a term of imprisonment, we submit that would take out and destroy his current employment prospect and his future employment prospects, and it would exacerbate his mental health. My client wants to be a productive member of this community, and our submissions are put forward in alignment with that. If Your Honour was, however, minded to impose a term of imprisonment, we submit that my client's mitigating factors and his distinguishing factors of offending, the amount in particular, and the limited and the unsophistication of it, we would ask Your Honour to exercise your discretion in wholly suspending any term of imprisonment that you might be minded to impose. If it pleases the court, those are my submissions. If I can't assist the court any further, thank you.